Post permission may proceed with my argument.
Proceed.
Thank you. Sir, on 11 April 2024 at around 11:55 p.m. at night, the accused, after being refused a bicycle by the complainant, became aggressive, abused him, and later assaulted him with a lathi. The complainant, who had gone inside his house to avoid confrontation, was forcibly brought out and beaten by the accused, resulting in multiple injuries. The incident was witnessed by independent persons including Lala Srivastava, Kundan Singh and Manju, whose testimonies supports the prosecution's version. The FIR was lodged on 12 April 2024 at 12:45 am, and the complainant was sent for medical examination, which revealed 8 contusions confirmed in the MLC report, which is EXP6, prepared by Dr. PW5. The accused defense is based solely on denial and is not substantiated by any evidence. His claim that the injuries were old is contradicted by medical expert opinion. Sir, the prosecution witnesses has remained consistent and credible. Sir, in page number 4, I have mentioned first main point, which is motive and initial altercation. Sir, on 11 April 2024 at about 11:55 p.m. the complainant was fetching water from a public tap. The accused asked for his bicycle, which was refused. Upon this, the accused started abusing, showing aggressive intent and coercive behavior. Sir, the demand of property, which is bicycle, and consequent assault upon refusal establishes a motive linked to extortion, fulfilling a primary ingredient of section 119 of BNS. I also had mentioned one case law, which is State of MP versus Munna Lal, All India Report 2010. In this case, the court clearly held that if violence is used with the intent to obtain property or any object by force, it fulfills the element of extortion under section 119 of BNS. So the second major point is escalation of threat. Accused brought lathi. So the accused, upon being denied the bicycle, accelerated the situation by going to bring a weapon, lathi. This demonstrates preparation and intention to use criminal force. So the complainant, seeing this, went inside his house. However, the accused forcibly entered, dragged the complainant out and assaulted him, proving voluntary hurt and coercion. Sir, I also had mentioned one more case law, which is Virendra Prasad versus State of MP 2003. In this case, the court clearly held that bringing a weapon and then using it on the victim clearly shows premeditated assault with intent to extort or punish refusal. Sir, in page number 5, I had mentioned third main point, which is assault and causing hurt. The accused beat the complainant with lathi, resulting in the complainant falling and suffering 8 contusions on different parts of his body. This clearly proves voluntary causing hurt using a weapon, fulfilling section 119 of BNS, which covers causing hurt to extort or compel any act. Sir, there is also a medical evidence. Sir, Dr. PW5 corroborates injuries in MLC report, which is EXP6, as being fresh injuries and consistent with lathi blows. Sir, in the case of Ram Sarup versus the State of Rajasthan, All India Report 2008, the court held that medical evidence consistent with ocular evidence of assault is sufficient to hold the accused guilty of voluntary causing hurt. So the fourth major point is immediate and spontaneous FIR. So the complainant lodged the FIR within 50 minutes of the incident at 12:45 am, showing absence of delay, spontaneity and truthfulness. Sir, in the case of Jai Prakash versus State of Haryana, All India Report 2014, in this case the court clearly had that prompt FIR lends strong corroboration to the prosecution case and reduce chances of false implication. So the fifth main point is credible eyewitnesses present. So the incident was witnessed by Lala Srivastav PW3, Kundan Singh PW4 and Gopal Giri PW2. These are natural, independent and reliable witnesses. Sir, I also had mentioned case law regarding it. State of Punjab versus Jagir Singh. In this case, the court clearly had that testimony of independent eyewitnesses has high probative value. Sir, in the case of State of UP versus Krishna Gopal, All India Report 1998, in this case, the court clearly had that an injured eyewitness's statement should not be discarded unless compelling reasons exist. Sir, in page number 8, I had mentioned my prayer. Sir, the prosecution respectfully submits that the evidence led in this case, both oral and documentary, has conclusively established the guilt of the accused beyond all reasonable doubt. The complainant PW1 has given a consistent and reliable account of the incident, which is corroborated by the eyewitnesses PW2 to PW4 and the medical evidence given by the doctor PW5 through the MLC report EXP6, which confirms 8 contusions sustained by the complainant. The act of the accused is assaulting the complainant with a lathi, causing grievous injuries. After demanding his cycle, clearly attracts the provisions of section 119 of BNS as the assault was in connection with an extortion attempt. The recovery of the weapon is not essential to prove the commission of the offence when the direct and medical evidence stand firm. It is humbly prayed that this honourable court may kindly be pleased to convict and punish the accused in accordance with law for the offence punishable under section 119 of BNS and pass any appropriate sentence in the interest of justice and public order in the rule of law. Thank you.
Honorable Court, may I start with my arguments? Proceed. Honorable Court, today I stand before you to represent the accused who has been wrongfully charged in this matter. It is our firm submission that the allegations brought forth by the prosecution are not only unsubstantiated but are also riddled with inconsistency and lack of evidentiary support required to establish guilt beyond a reasonable doubt. At the outset, it must be noted that there is no prior enmity between the accused and the complainant, removing any possible motive for the alleged assault. The defense will demonstrate that the injuries sustained by the complainant were old, not inflicted on the date of the alleged incident. Moreover, no independent eyewitness has testified to witnessing the actual act of violence, and the incident is said to have occurred in the dark of night, further weakening the reliability of the prosecution's narrative. The alleged weapon, a lathi, has not been recovered, and no direct evidence linked the accused to the use of any weapon. The defense will show that the complainant's injuries could have resulted from an accidental fall. Page number 2, not from any assault. As is being claimed, the medical evidence does not conclusively prove the prosecution's theory and instead raises doubts about the timing and nature of the injuries. We urge the Honorable Court to consider these facts and the lack of credible evidence, and we are confident that upon a careful evaluation of the material before this court, it will become evidently clearly that the prosecution has failed to prove its case beyond reasonable doubt. Therefore, the accused is entitled to an honorable acquittal. Some points mentioned in page number 3, sir. Point number 1, no direct evidence and lack of independent witness. The alleged incident occurred around midnight, and the absence of independent eyewitness raises doubt about the reliability of the prosecution's case. Though witnesses were examined, their testimony may lack credibility due to possible bias or inability to clearly observe the events at night. In this point, one case law is mentioned. Kaliram versus State of Himachal Pradesh, AIR 1973 SC 2773. If two views are possible, one pointing to the guilt of the accused and the other to his innocence, the view favorable to the accused must be adopted. One more point, page number 3. Old injuries, medical evidence does not corroborate the allegations. The defense, page number 4, the defense has contended that the injuries were old and not caused on the date of alleged incident. No conclusive medical evidence linked the injuries to the date or the alleged assault. In this also some case law is mentioned. Lakshman Singh versus Poonam Singh, AIR 2004 SC 1803. The Supreme Court held that medical evidence must specifically corroborate the timing and nature of injuries. To support prosecution claim, mere presence of injuries is not sufficient. One more point is mentioned here: no recovery of weapon. The alleged weapon largely used in the offense was not recovered, weakening the prosecution's case significantly. The lack of physical evidence suggested a reasonable doubt. One more case was in page number 5. Sambhu Das versus State of Assam, AIR 2010 SC 3300. Failure to recover weapon of offense does not per se render prosecution's case doubtful, but it certainly affects the credibility if other evidence is weak. No motive and no prior enmity. The evidence has argued that there were no prior enmity between the parties. The absence of motive further weakens the prosecution's claim, especially in a case involving serious allegations like assault and extortion. One more case law is mentioned here. Sarwan Singh, Ratan Singh versus State of Punjab, AIR 1957 SC 637. Motive is an important element in cases based on circumstantial evidence. Absence of motive can tilt the balance in favor of the accused. Sir, page number 6. Burden of proof not discharged by prosecution. The prosecution has failed to prove the case beyond reasonable doubt. All elements of the alleged offense under section 327 of IPC causing hurt to extort property must be proved strictly. The prosecution evidence lacked clarity and consistency. In this one case law is mentioned, Sarad Birchand, Sharda versus State of Maharashtra, AIR 1984 SC 1622. The court retired that every link in the chain of circumstances must be complete and conclusive to establish guilt. Page number 7. The accused in his examination under section 313 of the Bharatiya Nagrik Suraksha Samhita stated that the recovery of the lathi is not proved. He denied all allegation and asserted that he has committed no offence. The injuries on the complainant were not sustained on the date of the alleged incident. Rather, they were old injuries which could have occurred due to the fall or other accidental cause. there is no direct eyewitness to the incident due to it occurring in the dark hours of midnight, further weakening the prosecution's claim. Moreover, the defense highlights inconsistencies in the statement of prosecution witnesses and the absence of independent corroboration. Hence, the evidence presented does not establish the guilt of the accused beyond reasonable doubt. Sir, some case law regarding in favor of accused. Sharad Veer Chand, Sarda vs. State of Maharashtra, AIR 1984 SC 1622. The prosecution must establish its case beyond reasonable doubt and must stand on its own legs. Second case, page number 8, VD Jingan vs. State of Uttar Pradesh, AIR 1966 SC 1762. Court said suspicion, however grave, cannot take the place of proof. One more case, sir, State of Rajasthan vs. Rajaram, AIR 2003 SC 3601. The court held conviction cannot be based merely on the medical evidence without corroborative eyewitness testimony. In the case of Rajkumar Singh vs. State of Rajasthan 2003 5 SCC 722. The court held a statement under section 313 CRPC can't be the sole basis of conviction. Page number 9, sir. In the case of State of UP vs. Ramveer Singh 2007 15 SCC 372. The court held delay in lodging FIR and contradictions in the witness statement weaken the prosecution case. In the case of State of Punjab vs. Balkar Singh, AIR 2004 SC 4320, the court held failure to recover weapon of offence is a serious lacuna in prosecution's case. In the case of Babu vs. State of Kerala 2010 9 SCC 189, court held if two views are possible on the evidence, the one in favor of the accused should be adopted. In the case of Ramanand Yadav vs. Prabhu Nath Jha 2003 12 SCC 606, the court held evidence must be consistent, minor contradictions may be tolerated, but material contradictions create doubt. In the case of Suraj Mal vs. State Delhi Administration, AIR 1979 SC 1408, the court held mere recovery without evidence linking accused to offence is not sufficient for conviction. In the case of Kali Ram vs. State of Himachal Pradesh, AIR 1973 SC 2773, the court held in the case of doubt, benefit should go to the accused. In the case of Subramaniam vs. State of Tamil Nadu, AIR 2009 SC 1046, the court held absence of independent witness despite availability cast doubt on prosecution version. In the case of State of Rajasthan vs. Kashiram, AIR 2007 SC 144, the court held conviction must not be biased based on conjectures or surmises. In the case of Tehsildar Singh vs. State of Uttar Pradesh, AIR 1959 SC 1012, the court held a statement of hostile or unreliable witness cannot be relied on for conviction. In the case of Abdul Ghani vs. State of Madhya Pradesh, AIR 1954 SC 31, the court held medical evidence should match eyewitnesses' testimony. Discrepancy weakens the case. In the case of Dhanpal vs. State by Inspector of Police 2009 10 SCC 401, the court had allegations of assault require strong evidence, benefit of doubt should be excluded. In the case of Dhanpal vs. State by Inspector of Police 2009, 10 SCC 401. The court held allegations of assault require strong evidence, benefit of doubt should be extended where a story appears unnatural or exaggerated. My dear colleagues, showed some witnesses PW2, Lara Srivastava, Gopal Giri. I want to ask my dear colleague that at that time of night, where the Lara Srivastava able to clearly see the face of the assault accused?
Okay. So, sir, the defense claimed that incident occurred at midnight, so no one saw. Is weak because public taps and houses often have basic lighting. Sir, there are not so much lighting, but there are some sort of bulbs. It is very much visible to pupils. They can easily saw.
So I want to ask that what distance did he observe the incident? How much distant is it?
I don't.
The prosecution has failed to establish the guilt of the accused beyond reasonable doubt. The entire case hangs upon circumstantial and inconsistent evidence. It is contended that the injuries on the complainant were not caused on the date of the alleged incident, but were in fact old and possibly self-inflicted or due to accidental causes, as there is no credible eyewitness account verifying the alleged assault. The defense respectfully submits that the complainant's medical report, while documenting injuries, does not conclusively prove that the injuries were inflicted by the accused, nor does it indicate the exact time or mode of injury. The recovery of the alleged weapon lathi has not been proven, and there is no forensic or direct evidence linking the accused to the weapon or the act. Page number 13. Furthermore, the complainant's version appears exaggerated and unsupported by independent, unbiased witnesses. It is important to note that the incident allegedly occurred late at night in darkness, further reducing the reliability of the accounts given. The prosecution has also failed to establish any motive or prior enmity between the accused and the complainant. In the absence of such motive and with the lack of direct content evidence, the benefit of the doubt must go to the accused. Hence, the defense prays that the Honorable Court considers the above facts and acquires the accused of the all charges. Thank you.
So the first point which is mentioned by my colleague that there is no eyewitness present. So but I had already mentioned that the incident in page number 6, para 5, the incident was witnessed by Lala Srivastava PW3, Kundan Singh PW4 and Gopal Giri PW2. These are natural, independent and reliable witness. So the defense claimed that incident occurred at night, so no one saw, is weak because public taps and houses often have basic lighting and midnight presence of neighbors in a small town is not unusual. So the second point which is mentioned by my colleague that recovery of lathi not essential. So the accused claimed that recovery of lathi is not proved, but that is not fatal to prosecution because injuries are proven by the medical examination. Eyewitnesses confirms the mode of assault and the weapon used is common and easily disposed. So after this incident, the lathi are very much easy to dispose anywhere. So it doesn't matter. I also had mentioned one case law regarding it in page number 6. Gurmel Singh vs. State of Punjab All India Report 1982. In this case, the court clearly held that non-recovery of weapon is not significant if injury and testimony establish its use. Sir, in page number 7, sir, the defense plea that injuries are old and disproved by medical evidence, sir, which confirms fresh injuries. Sir, the accused also admitted presence at the scene according to section 351 BNSS, but failed to offer any plausible explanation or alibi. Sir, I also had presented medical evidence, which is in page number 5. Sir, there is a medical evidence. Dr. PW5 corroborates injuries in MLC report EXP6 as being fresh injuries and consistent with lathi blows. I just asked the court if defense want to say that the injuries are old, then why they are not giving any kind of medical proof which clarifies that the injuries are old. But in my case, sir, I had presented the MLC report, which clearly shows that there are 8 contusions on the different body parts of the complainant. Sir, my colleague also mentioned that there is a delay in FIR, but sir, the reality is, sir, the incident happened at 11:55 p.m. 11:55 p.m. and the FIR lodged at 12:45 a.m., which means within 50 minutes the FIR was lodged, which proves that there is a truthfulness in the statement of complainant. Sir, and one more point which is mentioned by my colleague, that sir, there is no motive. Sir, I had mentioned in page number 4, paragraph 1. Sir, the complainant was fetching water from a public tap. The accused asked for his bicycle, which was refused. Upon this, the accused starting abusing, showing aggressive intent and coercive behavior, which shows that the demand of property bicycle which is not fulfilled. That's why the accused used the lathi and injured the complainant. Thank you so much.
My colleague mentioned that the incident took place around midnight, but there is somehow. The colleague mentioned the medical examiner PW5 doctor. Can PW5 confirm the age of the injuries observed on the complainants? Is it possible that these injuries were not sustained on the date mentioned by the complainant? Are the injuries consistent with falling rather than assault? Can PW5 rule out any pre-existing injuries or conditions?
So I want to clear this point. Sir, the complainant had received 8 contusions on his body and medically examined by the doctor PW5, preparing MLC report. Sir, 8 contusions on his body, which means there is a fresh injuries. If anybody have old or very injury which is get from very long time, then the injuries were also very much common to see that the injuries are old. But there is a 8 contusions on his body which shows that the injuries are fresh. That's it.